Hi, good evening or good afternoon, depending on where you are. Welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Kyla Lee. She is out in Vancouver, a criminal defense and IRP lawyer. And I guess we can start right with that there. Maybe you can tell us your handle there on Twitter as well. What is IRP law? And maybe tell us a bit more about your practice and kind of how you got to where you are today.
Yeah, so IRP law is essentially the roadside prohibitions for drinking and driving. I think the last time we talked, they only had them in BC, but now they're spreading across Canada. So Alberta recently implemented a very similar system. There's one in Manitoba that's about to undergo some changes. There's one in Saskatchewan. So, and I hear word that they're coming to Ontario very soon. So it's basically a 90-day driving prohibition for people who blow a fail into a roadside breathalyzer. And so I deal with challenging that, doing the hearings before the Superintendent of Motor Vehicles Tribunal, judicial reviews of those decisions in BC Supreme Court. And then, of course, I also have a criminal law practice where I deal with criminal impaired driving cases and driving files.
Now, in terms of that, I mean, how often, where the police would choose to go criminally versus, certainly they have the discretion, but how have you found kind of that sorts itself out in the years that they've gone with this? I guess, if it does come in Ontario, what should we be expecting here, kind of how that's going to be implemented? What can you share?
Well, if it does come in Ontario for lawyers, it means probably not as much work dealing with criminal impaired driving files, which might make a lot of people breathe a big sigh of relief because they are very technical and complex. For people who are sort of members of the public, it means that the government can take away a lot of your rights in relation to driving with not a lot of evidence and not much in the way of a review process. So, for example, in BC, rather than blowing into a breathalyzer at the roadside and then being taken back to the police station, having the opportunity to speak with a lawyer, blowing into a breathalyzer there, you get punished right at the roadside. The punishment starts immediately and it continues until the prohibition is revoked, if it gets revoked. So you're guilty until proven innocent. And unlike in a criminal case, the burden is on you to prove your innocence. And there's no cross-examination. There's no ability to compel disclosure. You get certain documents that the officer sends in. And beyond that, you basically have to come up with evidence to demonstrate that this prohibition isn't justified in a circumstance where the deck is stacked against you.
And maybe you can walk through, because this is completely new for us here, right? Is let's say so you don't get a call right at the roadside, but someone says, "Hey, Kyla, I got this ticket. What do I do next?" Can maybe walk us through that process? And you're mentioning, there's not that much disclosure, and kind of what goes in if you're defending someone on that kind of charge.
Yeah, so for us, the first thing we do, you've only got 7 days to dispute it. Like the onus is also on you to dispute it. So once we get a call from somebody and we get retained by them, then we go to the driver licensing office. We have a staff member whose job it is to go down there and file all the applications every day. So we file the application to dispute it. Once the application's filed, then you're entitled to your disclosure, not before. So you can't review it and go, I don't know if I'm going to dispute this. You have to give your $200 to the government and hope you have a defense. Otherwise, you're out $200, plus any legal fees associated with that. And then we review the police report. Usually I have some specific questions for my clients about some of the things I see in there or potential defenses that arise based on the type of case. I have a conversation with my client, and then we determine whether or not to move forward with the review hearing. And if we do, because there's no cross-examination of witnesses allowed, and because the hearing is an administrative hearing that takes place by telephone only, we prepare all of the evidence in writing. So then I spend the next couple days working on written submissions, the affidavit evidence of the client, and preparing myself to make the oral submissions in the hearing. And at the hearing, I only get 30 minutes. So if I can't fit in all the arguments, like say a client has 10 defenses, if I can't fit those in the 30-minute hearing, too bad, I don't get to make them. So I try and make a lot of my arguments both in writing and orally so I can focus my submissions due to the limited time.
And so what are the kinds of things that you would be raising that, would attack, the evidence there, or like what kind of comes up?
Yeah, there's lots. One thing that we raise often in these review hearings is issues about things that can affect the reliability of roadside breathalyzers. So the roadside device, it can test for alcohol, but it doesn't differentiate between alcohol that's in your bloodstream and alcohol that's just in your mouth. So if you have like a recent drink, mouthwash that contains alcohol, candies, gum, chewing tobacco, all sorts of these things can actually cause false readings on the test. And there are so many things that people don't even think about that can lead to false results. I'm going to give a shameless plug here. I have a YouTube channel, and on my YouTube, there's a video series called Can You Fail It, where we test common items to show whether or not they produce positive readings on a breathalyzer.
And I guess that later, probably at the end, I'll ask, kind of where we can access some of your, we're going to talk certainly about all your social media presence, but maybe you can give us a little trailer or spoiler here of what are some of the things that can result in a fail.
Hot cross buns, surprisingly, yeah, like bread products, because of the yeast, there could be like a little bit of fermentation that occurs that produces alcohol, and the device can't detect that alcohol and differentiate like a very minute amount of alcohol from a very high amount of alcohol that's in your bloodstream. So if you get a test administered right after you're eating a very bready product, particularly something that's a little like sort of squishier, I guess, to describe it, like a hot cross bun or a cinnamon bun, that would produce a false positive. The classics like mouthwash and recent consumption, soy sauce, ponzu sauce, actually most Asian dressings, because of the fermented soy product, produce false readings. Kombucha, Red Bull in the US, but not Red Bull in Canada, because the ingredients are different. Yeah, those are a few.
Now, I mean, in terms of then raising those points, and certainly, if it goes through a criminal process, right, then they would test you at the police station with, the different testing, right, that was gives you the more precise measurement, and usually over the period of time, I mean, you're not going to have as much of that issue, but it doesn't get that far, right? I mean, that's it. They if they want to just give you the ticket, and then what are the consequences as well if you do get that?
So yeah, they give you the ticket right away. That doesn't matter if there's something that affected it. There's no process to discover that. And the consequences are massive. So it's 90-day driving prohibition that starts immediately. Your car is impounded for 30 days and you have to pay for the towing and storage for the car. So it works out to about $850. Once the 90 days are up, there's a $500 fine, a $250 license reinstatement fee, a $31 short-term license administration fee, because instead of renewing every 5 years, now they put you on a 2-year renewal plan. And before you can reinstate your license, you have to register for a responsible driver program, which is like an alcohol education course related to driving. It's $930. And you have to register for that. You can get your license back while you're completing the course, but you only have a year to complete it. And if you don't complete it in that year, license canceled.
And so then all of that starts right away. So even if you're successful on a review, I mean, you maybe have incurred.
Yeah.
Okay, and so what happens, I guess, now, given that they do have the option, sometimes they do go with a criminal charge. Maybe you can kind of walk us through in that situation where they do say, okay, you know what, we're going to come back to the station and we're going to charge you with impaired, and we're going to prosecute under the criminal code, how that procedure is different and what goes in there versus in this route.
Yeah, so the criminal impaired procedure, you actually get to call a lawyer. So once you fail that roadside breathalyzer, then the police officer is required to read you your charter rights and warnings. So you get told you have the right to retain and instruct counsel without delay. You can call any lawyer you want. There's a 24-hour toll-free legal aid duty counsel number that I can provide to you, and so on. And then people get the opportunity to actually obtain legal advice, find out about the consequences that they're facing, make informed decisions about providing a sample instead of just refusing to blow without understanding the consequences. And They go back to the police station, and the samples are also taken at the police station in a much more sort of scientifically controlled manner, if I can put it that way. I mean, it's not that scientific, but so instead of it just being one sample into a roadside breathalyzer, unless you ask for a second test, under the criminal code, the samples are required to be 2 samples, a minimum of 15 minutes apart. They have to differ by not more than 20 milligrams of alcohol. So if you get one that's 200 and then you get one that's 130, this says scientifically there is a problem because the agreement doesn't make sense. So they're not supposed to differ by more than 20 because there's like a margin of error incorporated into the instrument, and BAC would be going down at, in 15 minutes, probably 5, but you never know. So they do all of that to make sure that you're getting a reliable reading. And in addition to that, the instrument itself has inside it a canister of gas. And that canister of gas has a known alcohol concentration. So before taking the sample, it takes a sample from that canister of gas and measures it. And then it says, the gas is supposed to be where we live at 82. If the instrument produces 82 or plus or minus 10% of 82, then it's like, okay, this is correct. If it doesn't, then it doesn't allow the testing to proceed. So it's got like actual safeguards built into it to try and eliminate the possibility of false results. There's one more significant thing about the process that happens at the police station, which is that in addition to all of those safeguards, there's also something in the instrument sort of commonly known as a slope detector. What it is it's a CO2 monitor, and it's monitoring through infrared analysis using, only a chamber about that big, but it works out to be 2 meters because it uses mirrors to reflect the light. And it's looking for CO2 levels that drop off, and it's looking for where the particles are when the light passes through it. And what it's looking for is rapidly declining levels of CO2 coupled with a rapidly declining blood alcohol concentration as measured on the infrared device. And the reason for that is if you see something that's dropping off really quickly, that suggests that it's alcohol from your mouth and not alcohol from your bloodstream, because alcohol eliminates from the blood at a very steady rate. So it tells the instrument this is a contaminated sample. And so the instrument it aborts the test and says mouth alcohol detected. Roadside breathalyzer does not do that.
And then I guess maybe you could walk through after the police station. So I know obviously we don't have our mask mandates anymore, so I can't pull out my lawyer said not to talk to you mask, or I have a bunch of them actually. But what happens next then when they call up the firm and they say, okay, I got this, I blew readings of 1.14 or something, and what do you do next?
Well, it's kind of the same process, because in BC, even if you're charged criminally, they still give you a 90-day driving prohibition that starts immediately. It's a different 90-day driving prohibition, so the consequences are slightly different, but it's still the same 7-day review process and the same process for the hearings. So that's the first thing we do, is we go dispute that. And the benefit of doing that, I find for my clients, is the officer for that has to prepare a sworn report. So as soon as I get the sworn report for that, I've got a piece of evidence that the police officers prepared shortly after the events that he swore to the truth of, that I can use for cross-examination down the road. And there's a ton of case law in BC where there's differences between those roadside reports and the reports that they provide and the evidence they give in court, and the officer's testimony gets rejected on the basis of it. So I want to have that. So that's the first thing I'm doing, is I'm getting that documentation. And then, the client usually would, if they're charged, they end up released on a promise to appear with a court date. So then we wait for the court date and we attend court on the date and get a copy of the Crown evidence and start dealing with trying to resolve it that way.
And I guess so you had mentioned obviously that since the changes, there's been a lot more criminal prosecutions of do they kind of have certain things that they look for? I mean, I know you're obviously not a police officer, but maybe have you noticed the ones that they tend to like repeat offenders, or is it like really high readings, or is it just kind of depends on Vancouver versus like Victoria or something?
It's all of those things. It's a combination. So Usually, if it's an accident, they won't issue a roadside prohibition, they'll go criminal, because the type of evidence that you need to gather for the roadside prohibition is not necessarily going to be available in the accident context. Similarly, high reading, somebody who's grossly intoxicated where they don't need the roadside breathalyzer to determine whether or not they're impaired, then they usually go criminal. Prior history definitely factors into it. The officers are trained to, they don't always, but they're trained to run the history. And if a person has had an immediate roadside prohibition in the last 5 years, they're supposed to go criminal. It doesn't always happen. Then obviously, like anything, injuries, death, bodily harm, or like other criminal offenses committed at the same time. You will find that like the municipal police departments that are busier, like Vancouver, are more likely to go IRP even when it's not warranted. And the RCMP is more likely to go criminal and to actually apply those policies.
And so you did mention there, and certainly we haven't talked about like impaired by drugs and stuff as well. But what the difference between being impaired, I mean, it's a separate criminal code offense versus being what we call over 80. Can you maybe explain to the students here like what the difference is, and maybe now we can certainly also talk about drugs there and how that is dealt with. And is it if you have is there kind of a similar thing for impaired by drug that doesn't go criminally in the same vein?
So in BC, we do have an impaired by drug prohibition scheme as well. Impaired by drugs, we have a 24-hour prohibition for drugs. So if an officer has reasonable grounds to believe your ability to operate a motor vehicle is affected by a drug, not impaired, just affected, and just on reasonable grounds, they can yank you off the road for 24 hours. There's also a 90-day drug driving prohibition, and that applies in a couple circumstances. So if they do a drug recognition evaluation test, and at the end of the evaluation, the evaluator forms the opinion you're impaired, they can issue it to you. They usually don't, though. What they usually do is they wait for the results of the urinalysis. And they're always taking urine in BC. They almost never take blood, and they never take saliva. So they wait for the results of the urinalysis that happens at the end of the DRE evaluation. And then there's a presumption, both in the criminal code and in our roadside prohibition law, that if the categories or classes that the evaluator called after the evaluation match what's in the urine, you're presumed to be impaired and impaired by that drug. So it's a lot harder to fight, which is why they wait for that evidence. As far as the difference between impaired driving and driving over 08, impaired driving only requires proof of that a driver's ability to operate a motor vehicle was impaired by alcohol or a drug or a combination of the two to any degree, even slight. So that means that if you have a person who has like a little bit of wobbly driving and they slur their speech and they stumble while they walk, that might be enough. If a judge finds that they're satisfied that that's proof beyond a reasonable doubt, that might be enough for a conviction. And the Crown doesn't have to prove what is the cause of impairment beyond alcohol or a drug or a combination of the two. So like an odor of liquor plus those observations would say that it's alcohol. An odor of cannabis plus those observations might say that it's cannabis. But they don't even have to have any of that. It could just be the only conclusion that's left after looking at all of the facts.
And what if they had, let's say, done a breathalyzer and you get like 0.04 or something? Does that change that?
It doesn't change it. Like, it doesn't mean that you couldn't get convicted, because although everybody is impaired at 80, which is the legal limit, people can be impaired at lower levels, especially when there's a combination of things. Like if you have too much caffeine and you're at 30, that might impair you. And caffeine's a drug, right? So, and if the alcohol is not it has to be a contributing cause to the impairment, but it doesn't have to be the sole cause. So there's lots of cases where people end up being under the limit, but convicted of impaired driving because of a combination of alcohol and fatigue. That's probably the most common one. And the criminal code has a separate offense for being over the limit. At trial, you can only be convicted of one of the two. So there's a provision actually written in the code, but it's just the pineapple principle, which is that if the evidence proves you're guilty of both, only one conviction can be entered and the other one gets conditionally stayed. So usually in these cases, the Crown will charge both because they have a fallback, because the impaired is a lot easier to prove because you just have to prove that slight degree of impairment, and bang, bang, boom, criminal record, 1-year driving prohibition, $1,000 minimum fine.
Now, one of the things we didn't talk about in relation to all of this, right, is well, what if the police had no reason to even pull you over, right? Like if there was a potential charter argument, whether criminally or even on the IRP side, right? If there was just no reason, and how does that all factor into, let's say, how those could progress and what you can raise at potentially a trial about that whole process?
So I'm not sure I fully follow.
Okay, so if there is potentially a charter issue, right? How does that kind of factor in on how you would raise that?
Yeah, so I mean, one thing that lawyers are obligated to do, and every province is different as far as the relevant timelines, but in BC, minimum of 14 days before the argument is to take place, you have to provide notice of the charter arguments that you're advancing. Now, in actual practice, if you provide it 14 days, the prosecution will get mad at you. I usually provide mine before I schedule trial dates. So you provide your notice of the charter issues, and then at trial, usually the way that we do it here is most of the evidence is heard in a voir dire. So most impaired driving cases are maybe a couple civilians who made some observations of driving behavior, one police officer who pulled the person over. The person who took the breath samples is usually a different police officer, but they don't testify because all their evidence goes in by certificate. So it's really just a one Crown witness case many, many times. Sometimes there's some civilians, but they're almost never relevant to the charter issues because they're not state agents. So all of the evidence of the main investigating officer tends to get heard in a blended voir dire, and all of the charter arguments that are being raised get heard and argued in the course of that voir dire. So you might have the officer might testify in direct for 45 minutes, and it's just everything that they would say in the course of the trial. And then you cross-examine, and you're making all your cross-examination stuff. And then at the end, and I know our Court of Appeal says don't do this in drug cases, but it works really well in impaired cases, because the only thing that you really have to sort out at the end of the day is observations of impairment that were made after the person was, arrested. Are those admissible? And breath sample results or refusal to provide breath samples, is that admissible? So it's really just kind of one piece or one body of evidence that's subject to the application for exclusion. So even though there are different burdens where, like the Crown has to prove that they implemented 10B rights, or that the 10B rights were waived, and that they offered 10B, but if it's an issue of satisfaction, then the burden is on the accused to prove that they, diligently pursued their 10B, and that the waiver wasn't a waiver. If you an ASD sample, the burden is on the Crown because it's Section 8 issue, but if it's an arbitrary detention, the burden is on the accused. So it doesn't get that complicated though, because usually the defense just agrees to go first, and because the burdens are in different places, and that seems to work well.
And then if you're successful on raising that, then what happens?
Well, if you win the judge finding that there were charter breaches, then you go to the next question of whether or not the evidence should be excluded. And you guys in Ontario have it crappy, because there's this awful Ontario Court of Appeal decision where the ONCA is like, no, the Supreme Court of Canada basically said breath sample evidence should always go in, which is wrong, and they don't follow it here in BC. And obviously they weren't saying that because when they were writing Grant, the Supreme and the Grant and Subaru and Harrison and what's the other one? Shepherd, that quadrilogy or whatever it's called, quartet of cases. They were mad about the Stillman rule that automatically excluded evidence as long as it was conscriptive. And they said you can't have 24-2 is not meant to be interpreted in a way that leads to an automatic result just because of the type of evidence. And yet now the Ontario Court of Appeal is interpreting it that way. Sorry, that's some inside baseball, deep nerdy stuff. So hopefully there's some deep nerdy law students listening to this. So yeah, then you have your application for exclusion of evidence.
And then depending on how that goes, then there's no breath sample, there's no proof there.
Yeah. And so if you win that, then there's no breath sample. And then the Crown will look at it and they'll either go, there's enough evidence that we're going to argue about impairment, or they'll just drop everything else. Because usually there's no impaired. Like they charge it just in case, but the evidence doesn't come out right. Sometimes they have it impaired, but then there's reasonable doubt, right? So
All right, so let's switch gears. And thanks for all that information there about impaired driving, both on the IRP side and then on the criminal side. I know since the last time we talked, you have a couple of books that have come out. So you could tell us a little bit about what that process was like and what the books are, and
yeah.
what practitioners, whether in BC or in Ontario or anywhere in between, can gain from purchasing those materials.
Okay, so I wrote two books because there was a pandemic and there was no court, and I felt like I had nothing but time in the world. So I agreed to write two books, like a crazy person. And then my nothing but time in the world went away when court here resumed. In BC, we resumed court in June 2020. So I had gone from March 2020 thinking, oh my God, my life's going to be great. Like this pandemic's going to last forever. And then, oh no, we found a way to make court totally safe, back to in-person court as of June 2020. So then I had to write the two books. So I'd had a vacation planned that obviously I wasn't going to be able to take. And I took my vacation time and I holed myself up in a hotel in Nelson, British Columbia. And I sat there and I wrote. Like I didn't leave the hotel room except to eat. Nelson, I'm sure you're beautiful. I saw four walls. But yeah, I wrote two books. The first one is called Cross-Examination, the Pinpoint Method. Obviously, because most of my criminal law work is cross-examining to try and establish charter breaches. I like to think I'm okay at it, okay enough to write a book. And it's available on LexisNexis. And then the second one, which I happen to have right here, is called Immediate Roadside Prohibitions in Western Canada. So it's about the BC IRP scheme, as well as a little bit on Saskatchewan and Alberta. At the time that I wrote the book, Alberta's scheme had just been announced and they hadn't published all of the regulations. They weren't even issuing them yet until after the book was like finalized and gone to print. So maybe they'll do a second edition with more on the Alberta stuff. But the book is useful to anybody who's dealing with roadside prohibitions in Canada, because all of the case law on this area is most litigated in BC. So like the judicial review stuff and the responding to evidence, interpretation of evidence in the admin law context, something that's probably not familiar, especially for criminal law practitioners, useful in here. And obviously cross-examination is a good skill for anyone to have.
Yeah, so maybe you could give us some highlights there about the pinpoint method and cross-examination, and just maybe tips here for students. I know when we do our mock trials, and we have one coming up, that always tends to be the toughest area, right? So what can you share from either in your book or from your own experience there?
I think like planning is number one. A lot of lawyers make the mistake, especially lawyers who are more senior. They think, well, I've done this before a lot, and so I know how to do it. So I don't have to script or draft my cross-examination. I can just go in. I know what the evidence is. I know what I'm going to ask. And that is the easiest way to get caught with your pants around your ankles looking like an idiot in court, because you didn't anticipate something or you didn't think through it. So I recommend, and I do this, script every cross-examination. It's an exhausting exercise at the beginning. Like at the beginning, you're going to take hours and hours and hours to do your first, and it's going to be terrible. I still keep on my computer over there my very first cross-examination that I ever wrote, so I can look back at it and like feel bad for myself. No, it's a good like reminder to me of how far I've come professionally. So scripting is a big deal, and knowing what the evidence is and laying it out and understanding what you want to achieve with the evidence well in advance. So in my book, I actually demonstrate a little method of creating charts for different types of evidence and how to slot the information into those charts that then will naturally flow into drafting your questions. And the third tip I'll give, never, ever, ever pass up an opportunity to impeach a witness. Anytime you can impeach them, even if it's on something small, that might be the straw that breaks the camel's back for the judge. And I realized that once when I had a trial, and the officer had, in the course of the trial, the investigation, had pulled my client over and seized some things from the vehicle that maybe were obtained by proceeds of crime, or at least that was the theory. This was three big men. There was a bag of bras in the vehicle that belonged to like one of their girlfriends. And at the end of the cross-examination and the Crown's redirect, the judge says, okay, officer, I just have a couple questions for you. Why on earth did you seize the bag of bras? Like, that was the thing out of everything that had happened that was so important to him, was this officer seizing in a drug investigation a bag of bras that clearly have nothing to do with what he's investigating. But to him, this was this action, this unlawful action undertaken by the officer that we didn't really touch on. Like, it came out indirect, but we never touched on it in cross, because what does it have to do with anything? It was a seizure. Yeah, it was unlawful, but who cares, right? It's a bag of bras. Where you get the bras excluded, okay. But for him, like, that was the thing that pushed him over the edge with the officer. So now I say never pass it up, because you don't know what's going to make that judge mad about the police conduct.
Perfect. And certainly, I also want to talk to you here with a little bit of time we have left. I know you have you mentioned it before, there the different things you do on all the different social media. So maybe you could kind of share. I know we often have a perception of lawyers as, very by the book, or very traditional. Some of the different things that you're doing, first of all, and kind of the importance of kind of putting yourself out there, and whether it's the cases that should have gone to the Supreme Court, or you mentioned the things that can fail the breathalyzer tests, and the music videos and so forth. Kind of what are the things that you've done, and how you found, I think you have like 25,000 followers on Twitter there, how that's been in terms of, your practice and everything.
I mean, for me, it's obviously like it pays dividends in the sense that it's marketing and people know who I am. And so they're, when something happens, they already know Kyla Lee is the lawyer to call for the DUI, right? Like that. And that's good. But the thing that's more important to me about it, and probably what keeps me doing it, because sometimes I get exhausted because I'm so busy working. And if I'm busy working, I do not need to be marketing to get more clients. Is I feel like it's so important to keep the public educated. Like, to tell the public, these are your rights. This is what officers can and can't do. This is what you need to know about these issues that are going to affect you. Because the type of stuff that I deal with, the vast majority of my clients are people who never have any other contact with the criminal justice system or with police. Like, the one time they deal with police in their life is the time they get their DUI, or the time they get their speeding ticket, or the time they get their roadside prohibition. And because they're not people who are like actively learning about how to deal with police from their continuous history of being involved with police, they are at a disadvantage by not knowing the system. So I want to make sure as many people as possible know the system, know their rights, know their obligations, so they don't make the wrong decisions. And it's just, to me, like, educating the public about the law. I think we're woefully uninformed about the law in this country generally. And I think the biggest example of that is these protest convoys. People have been going around the country honking their horns and waving their flags and saying, we're here and this is a violation of our rights, to make us wear masks, or to tell us that we can't get on a plane unless we're vaccinated, or to make us show proof of vaccination to go into a restaurant. They don't understand what their rights are. None of those things are your rights. And they don't understand how the government can limit your rights. So for me, educating the public about that, I think, makes a public better armed and informed to deal with the police if and when those situations come to pass.
All right. So can you share, I guess, where we can reach some of those things, and how people can follow you as well?
Yeah. So in Twitter, you can find me at IRP Lawyer. I just got verified too. I was kind of excited about that. On TikTok, I'm Kyla Lee Lawyer. Also Kyla Lee Lawyer on Instagram, and on YouTube. The YouTube channel is Acumen Law, and you can find links to all of that on my website, kylalee.ca.
Perfect. So thanks again for joining us here today and sharing about all of that. Any final words of wisdom here for students and everyone listening? We're looking to enter into a career in law and are studying criminal law right now. We're in provincial offenses. Any advice from your perspective?
Well, I'll give my typical advice that I always give to students, which is if you're interested in it, reach out to lawyers who practice in it and pick their brains. Lawyers will make time for students and make time to talk to students and educate them. If they don't respond to you, just follow up because they probably just forgot because they were busy or they didn't know how to do math and calculate time. um, and the other thing I would say is there's always a benefit in inviting a lawyer out to lunch because there is an unwritten rule in the legal community that if you're a student and a lawyer is going to lunch with you, the lawyer will always pay. So it is the one guaranteed way to get a free lunch.
Perfect. Thank you again for joining us there and sharing about all of that. I wish you all the best. And again, follow her on Twitter there. There's so much more information, like she mentioned there, that you get a lot of understanding of the various laws and very cool and innovative ways. And I think that really, again, really gets through to the public that you can understand it in a more simple way rather than something that's very complex. Thanks again, Kyla. Take care, everyone.
Yeah.